I've been in the Navy for 19 years. Of those 19 years, 12 of them I have been a legalman. As a legalman, I have the privilege to help enforce the policies and rules governed by the Uniform Code of Military Justice. What I'm going to speak to you about today is how to complete a non-judicial punishment package / hearing from start to finish. Non-judicial punishment is a form of punishment authorized in the Navy. The Navy gets its authority to perform non-judicial punishment from the Uniform Code of Military Justice, Article 15, which was established in 1958. There is also direction contained in the Judge Advocate General's Manual 5800.7 Echo, Chapter 1. Now, the first step in this process is a sailor has to commit some form of misconduct. For example, a sailor gets into a fist fight with another sailor and detained by security. Security would do a preliminary inquiry into the facts and circumstances of the case and forward the investigation to my office. As the command legalman, I would review the case and brief the chain of command. Once the chain of command and I establish a way ahead, I will look in the manual for court-martial and locate an appropriate charge based on the facts. Now, each charge has certain elements that must be met to charge the charge. For example, the elements for assault consummated by a battery are A, that the accused did bodily harm to a certain person, and B, that the bodily harm was done with unlawful force or violence. If both elements were not met, I could not charge the accused with assault consummated by a battery. In this case, let's just say that we've met the elements. I will now draft a NAVPER 1626/7 Report and Disposition of Offenses. This will contain the accused sailor's personal information, the charge and specification, and the member's current enlistment information. At this point, I will also draft the accused notification of rights. At a non-judicial punishment hearing, the accused has certain rights. These rights are limited to the right to have the Article 31 Bravo rights read to them, the right to see all evidence against them, and if on shore duty, the right to refuse non-judicial punishment. Once I get the paperwork drafted, I will bring the accused into my office and inform them that the commanding officer is contemplating imposing non-judicial punishment and explain the current charges and advise them of their rights. At this point, the accused has the right to consult with a lawyer. If the accused does consult with a lawyer, the lawyer will go over the remainder of the form and the rights with the accused. If the accused does not elect to talk to a lawyer, I will complete the form with the accused. Now, let's just say the accused has elected non-judicial punishment. There's a process that I like to follow. Not all cases need to go through this process, but I like to work out the kinks and gain all the pertinent facts for the commanding officer. The first step in this process is called a disciplinary review board. This board is comprised of members from the chief's mess and is purely a fact-finding body. The chairman of this board is the command master chief. The board members will take turns asking the accused questions in regards to the case. Now, if at the end of the DRB, the disciplinary review board determines that the case is weak or there's a more appropriate way to handle the case, the DRB has the authority to dismiss the case. For the purposes of this speech, let's just say the DRB has recommended the case move forward. The next step in this process would be Executive Officer's Inquiry, XOI. This too is a fact-finding inquiry. It is a little more formal than the DRB. Again, if the XO finds the facts to be weak or there is a more appropriate way to handle the case, he or she can dismiss the case at this point. In this instance, we're going to say the XO has recommended the case go on to Commanding Officers NJP. Now, Commanding Officers NJP is a more formal hearing with members from the accused chain of command. There's going to be witnesses and members of the command element such as the chaplain, members of the Master at Arms staff, the Simeo, and myself, the command legal officer. The commanding officer will hear the case and make a determination of guilt based on the facts of the case. An interesting point about non-judicial punishment is that the burden of proof is much lower than that of a court-martial. The burden of proof at non-judicial punishment is a preponderance of the evidence. Basically, it is more likely than not that the offense was committed. Now, at a court-martial, just as it is in the civilian sector, the burden of proof is beyond a reasonable doubt. The commanding officer has found the accused guilty of the offense charged and awards punishment at this point. The maximum punishment authorized at commanding officer's non-judicial punishment is reduction, 1 enlisted pay grade, 45 days restriction and extra duty, and to forfeit 1/2 month's pay per month for 2 months. After the commanding officer finishes the NJP hearing and dismisses the accused, I will bring them into my office and ensure he or she understands what has just happened. At this point, I will explain the right that the accused has in regards to appealing the CO's decision. Now, there are 2 grounds for the appeal. The first ground being that the punishment was unjust, meaning that it was not warranted. The second ground for appeal is that the punishment was disproportionate to the offense charge, meaning that there was too much punishment awarded for the charged offense. The appeal must be in writing and submitted within 5 working days, and it will go to the commanding officer's boss. In closing, NJP serves 2 functions. It can correct the deficiency of the accused sailor, and it also serves as a deterrent to all other sailors. As I stated earlier, as a legalman, I am part of a great organization, the JAG Corps and the legalman community, that helps maintain good order and discipline in the United States Navy.